there's been a big debate about this, but I can't find the word now. And I think it depends on in what context, because and it's equal. I mean, it's formally equal. But
why did you choose to study law?
That's not a tricky one, or both. My name is anyway Ulrika Andersson, and I'm a professor of criminal law here at Lund University. And I think it's more of an interpretation of myself. Why I started studying law is that I wanted to have power. But I wasn't aware of that at the time, because I was actually interested in psychology and law. And so I picked psychology first, but then I decided I wanted to, have an opportunity to choose later. I thought law was wider. But when I have, analyzed myself afterwards, I think maybe it was because I wanted to have more power. I don't know, it could be. But anyway, I've always been interested in societal questions, and I was also curious, but because I don't have an academic background at all. So I was the first one at university. So I think, I wanted to have opportunities later in life or something.
And what do you think, what kind of opportunities can you get through law?
I mean, I think what I'm doing now is actually the best job to have as a lawyer, because you are really free. You can decide. I mean, to a certain extent, what to do research about if you get funding and if you're lucky. So then you can decide what to do, and you can do research about important stuff, and then you can try to influence the students, and that's a perfect combination. And you have contact with young people. I mean, the future. So, yeah. So
that's what I thought, actually, that you would be able to influence people who are going to use law later on.
Yeah. So I think it's a very good job. And interesting, of course. I mean, all jobs has its ups and downs, but yeah.
And what do you research in? What are your fields of research?
I'm doing why I started is not that I picked criminal law because I was very interested in criminal law as such, which I am, of course. But I had a topic that I thought was so important that I needed to do research about it. So that's basically it, and that was sexual offences and the proof process, which I found at the time when I started in the end of the 80s. End of the 90s. Started doing research. I was so angry with the system. I wanted to have a look at it and see what I could do. Why was the victim focused? Why I thought all these things with victim blaming. Why the victim was questioned and sort of blamed of the assault, and the focus was on the victim in the process. I wanted to see was this necessary and why was this the case. So that was basically it, and that's why I went to academia, because I started 2 years as a law clerk after my graduation, and that was really good to get an experience to see what it's like in at a court. But then I wanted to go back to academia.
And then, do you think anything has changed in the way the victim is? Since you started your studies.
I mean, both yes and no. I think the change has been really slow, but unfortunately, as you know, this topic is still very current. I mean, it's and it has been ever since. I mean, it's almost 25 years since I started doing my research, and I mean, it has been a really current topic ever since. So that's maybe on the positive side. I mean, we talk about these issues a lot, and law and I mean academics and judges and students are really aware and really interested in the topic, so we are more aware of certain stuff. So I think that has changed, and also law has changed since I came into the field.
In which way? Law has changed?
I mean, it has changed a couple of times, but the recent change in Sweden, which I know Denmark also has changed now, is that rape law is focused on consent or non-voluntariness, which some people think is a huge change. I think maybe not. Well, it is a huge change, but I mean, it's not a change that will change everything to the better out of the victim's perspective. But I think in the long run, the short answer is, in the long run, it is a change for the better. But you shouldn't put your hope only to law itself, because law can do certain things. It can change. You can have really important changes in law and necessary changes. But law cannot do everything, I think.
Can law influence society to change their behavior?
You mean the behavior, human behavior? I mean, I wouldn't be here if I wasn't, to a certain extent optimistic. But law in itself is a very slow business, and law is mostly leaping behind societal changes. Very rarely law is sort of in advance, ahead. My first project was about rape and the legal treatment of rape. So I studied how courts argued in these cases of rape against grown-up people, because and I studied the argumentation and the reasoning to see what is law shaping, how is law shaping the victim here. So that was my starting point. That law and the legal reasoning, not only the law, the statute, the paragraphs, but also the application, how the judges argue, and the reasoning in these cases. My starting point was that these reasonings were as important as the outcome, because this reasoning, this argumentation, how the structure of the judgments, they produce or shape objects and subjects in certain ways. And in my case, I was very interested in seeing how what do these reasonings tell you in terms of about the victim. And I could find out, I found out, I could show that even though law itself at that time was focusing force or violence and force and violence, and that was the most important way of separating sex from rape in the paragraphs. Even so, the reasonings of the court were more interested in how what the victim or the exploited person, how he or she reacted to this assault. So my conclusion was then that the argumentation told you that the victim should act in this way or that way. And mostly there was an expectation that the victim herself or himself had to react and show some sort of resistance.
Yeah, we've moved some way now that even silence can be interpreted as resistance in a way.
Exactly.
Yeah.
So that I was saying before. There has been a progress, definitely, but I think I can say that still the starting point is the same. The starting point somewhere is still that we expect a person to react, even though, but there has been a little bit of progress. I can say that, but I agree with that. But for example, Swedish law say that, and it's also explicitly saying so in the preparatory works to this latest amendment, that there is an awareness of passivity, that could be a sign of frozen fright, which is a very normal reaction we know from medical research. When someone is assaulted, and also in relation to sexual assault, you react with a frozen fright, which, that you don't know how to do. You just freeze, and that is a typical normal reaction. So that is one example of how the awareness has changed within the system. But so the law and the preparatory works explicitly say that passivity could be a sign of that. But at the same time, they say passivity from the person assaulted or the victim could be, well, not the victim, but person. Passivity is said like this, something like this. Passivity could also be an expression of voluntariness. So, but the norm is about to shift. Definitely, there is something has happened, because now there is this awareness. But we still see, how can I say it? We still see horrible judgments.
Yes.
Yes, but I think a lot of things have happened. The field of women's law, or feminist jurisprudence, it's mostly maybe translated, but women's law was used in I'm thinking now of the Nordic context. It was introduced in Oslo in the end of the 80s, or 85 or something, by Tove Stangdal, who wrote this women's law. And there, I think you can say the structural changes of women's position in society were more focused. So the starting point was more women's situation in society in relation to law. When this field first grew as a legal discipline, as I said, it started out at the Faculty of Law in Oslo, and it was called women's law. And I have a quote here because its objective was to describe, explain, and understand the legal position of women. And there was this specific aim, which was to improve the position of women in law and society. So that was the aim. And so it was quite, a large project, if you listen to it, if you take it seriously. And it was out of the starting point that law affected men and women differently. And they also had this special goal of contributing to the work of real equality and liberation. And yes, so law was mostly perceived as a tool, you can say, as a tool for change. So, but also you can say this was an optimistic view of looking at law, because law can actually change women's life. and they also had the ambition to chart and law in a different way. For example, they created the topic of husmorsrätt, housewife's law, almost in translation, husmorsrätt, and they wanted also to
which is what housewife
husmorsrätt is more. They created like a new field. So they created law out of different perspectives, out of women's experience. So that was also an ambition.
But what rights did women achieve through house? I mean, is it something which had an effect, a result?
I mean, I think you can say in the long run this has definitely affected, because the criticism of it started, a really important project also criticizing foundations of law, like law has an ideology of being objective and equal, and within this line of thought, it was shown that the objectiveness was more, in favor of men, or more out of a male view, you can say, and that it affected men and women differently. So in that way, it also changed important concepts of law, and it started and sparked off really important discussions, so that were taken for granted before. So that I could say.
So should men and women be treated differently?
Both. Because after the first wave, you can say that formal and onwards, formal changes were at place. But then the next project started when, looking at effects, the effects of law, and formal equality. We know now is not a guarantee for equality in real life. For example, there are studies that could show that rules in relation to divorce and marriage could when you split your own, what you own, what you keep together in a marriage, those rules that were affecting men and women differently. So that could lead to a change, for example. And also there are other studies that have been looking at the concept of working damage. Don't really know how to translate it. Arbetsskada in Swedish. Mm-hmm. What working damage that could affect damages or injuries that were more typical, causing that women were had been caused to women than men, and that they were more inclusive, those rules, in relation to men, for example. So that's two examples that where law can when it's applicated could lead to different outcomes. But then again, I'm a bit reluctant to generalizing too much because it could be, but those are obvious and good examples. But it could be that you essentialize. I mean that you think of women and men in essence different, and I don't believe that. I think that society's structures also shape, and so I think it's more important to look at how society and in this case as society's institutions, and then law is an important institution which you should explore and look at and see how is the law, you should do it the other way. How is law treating and how is law positioning men and women differently? And now we don't talk about men and women only, we also think of other power structures that could be in relation to class or color or sexuality or, and then those are really important as well.
Please tell us about the Metoo movement. Why did it start and where is it leading to?
In simple terms, you can say that the situation was right. But in what way was it right? Well, I think, first of all, you shouldn't underestimate the digital movement. That all these stories they were spreading, in 24 hours or less, all over the world. So it was huge, and so maybe the situation was right us the world was ready for all these stories, because for us feminists or people who have been working with these issues, sexual assault and sexual harassment and sexual violence for ages, these stories were not new, and the situation was not new, but the world was ready, so to speak, and it has to do with the digital movement or the digital revolution or whatever. So I think, but the story behind, or how can you say it, why it all, why it was taken seriously, it has to do with a problem that wasn't new, that there is what we call in research a justice gap, which means that there is only a fraction of stories that get through the legal system and get sort of recognized as legally relevant, and that get not only maybe a case at court, but also eventually a verdict. So this is what we call the justice gap. So only a fraction of the stories get through the system. And
it was mostly women, and women were also ashamed to talk about it.
Yeah, mostly women, but also other.
Yeah.
It also has to do with men being assaulted as well, of course. But mostly in Me Too was about women.
But suddenly, even some women began to turn against this Me Too movement. Yeah. Why?
The backlash. I think mainly the backlash personally has to do with this, that powerful men had to leave their jobs and without maybe formal procedure, because these things happened spontaneously, because employers got scared. That's also a sign of the power shift, because suddenly the power were in the hands of the victims, and they could step forward, as you said, without being ashamed, because they were being supported from so many all over the world, and they could step forward, and tell that this powerful man did this to me many years ago.
And it has had an influence on law, right?
I would say in
jurisdiction.
Yeah, and jurisdiction. I would say in Sweden, I would say that definitely it. How do you say it? It had it was judging. No, so sorry, nudging. It was nudging the movement towards consent based rape reform. I mean, it came into force earlier. I mean, it was already in progress, But I would say definitely that the Me Too movement, which was in the end of 2017, it was nudging our consent-based reform, because it came in. It was all not all of a sudden, but very quickly there was a decision and a unanimous political decision, and then the reform came into force in July 2018. So it definitely made it quicker, I would say. But it's not a reform which is the result solely of the Me Too.
What will you say is not only the result of Me Too? What more?
No, because it was a result after. I mean, this way of constructing rape has been discussed in Sweden at least since on and off since the beginning of 2000 or something, and it was a result of some verdicts that were criticized. And it has been going on and off, and at least twice there was various proposals in line with this. I mean, stressing consent instead of force, but they were rejected in the end. But then this was a third time, as I remember it now. Mm-hmm. And it was definitely helped by the Me Too movement.
You've been researching on the Me Too movement. What is your, how shall I say, your point of interest in the Me Too movement?
I have a project together with 3 other colleagues, and one of my colleagues here at the faculty in criminal law, and another colleague at the gender studies department, and then a colleague at the from a law faculty in Britain. Lund University, and we have been studying. The reaction from the legal sphere and also from social media, studying stories and witnesses from Me Too, and the concepts of justice. What were the demands? What was lacking from the victim's point of view? And how did the system react? So those were the questions. And we have been looking at the consent-based reform, and we've been studying defamation cases, because I don't know if you are aware that in Sweden we have at least 12 or 14 cases directly related to Me Too, where the women who stepped forward and talked on Facebook, for example, some of the women had tried the formal way, some hadn't. So they had, for example, made a police report about assault or rape or some sort of sexual violence, and the system didn't believe them. But in some cases, they didn't use the formal justice. But anyway, after Me Too, they used Facebook or some other kind of social media. And even though they didn't mention the name of the offender, in some cases they did, in some cases they didn't. And they were then reported to the police in their turn because of defamation. That they have been, defamation is when you tell someone is a criminal or you tell something bad, and you violate the person's honor, to put it simple. And in all these cases that we have been studying, it's actually my colleague who did this study. The women were convicted of defamation, so the court did not. So this has been really interesting, because in these cases you weigh the interest of being able to talk in a society and tell the view, the expression of your view, which is very fundamental, yttrandefrihet. Then the court weigh these interests, and it has to be defendable. They look at if was it defendable for this woman to go out in social media and tell about this. And one way it could be defendable is that if there is a political interest, and we argue that this could have been, it was possible, in short, for the court to take this Me Too movement into account, but they didn't. They convicted all the women, and this has been really highlighted internationally. This is quite unique. So we studied those cases, and we also studied people being active in the Me Too movement, telling their stories. And these are also work in progress, but we are about to publish now. But I can say that what is partly new and partly confirming earlier studies is that justice to victims of sexual violence and sexual harassment and sexual assault has a very shifting pattern. It varies over time. It can vary over time for each individual. It varies among individuals. So we are using this term that was coined by a scholar from Britain, Claire McLean. It's called kaleidoscopic justice. It is because it's shifting, as I said. And our results confirms this, that justice can be to be recognized, to get a voice, and to feel a connectedness. And you can get it, this can be achieved from what you can call justice without outside the formal system, but it could also be achieved within the justice system. And for victims, this can vary. You can get it from without, by telling your story in a social media setting, and getting recognition from other victims. But you could also get it from within the system, so to speak. And there is no unanimous way of getting justice for victims. That's our main conclusion. And that's very interesting.